Congratulations, you've made it to your final lecture for week 3. We're going to talk about mutual assent. And this is just a series of items. This is just a series of things we look at to determine if there really was offer and acceptance. Well, I thought we had it figured out already. We had offer, we had acceptance, so we had an agreement. Maybe, but maybe not. So there are some questions that we're going to look at. So did the parties enter the contract in free will? So that's the first one. Was this totally out of free will? And there are a few things that address that. Did they enter into the contract with full knowledge of the facts, or was one or both parties misled, perhaps on purpose or perhaps on accident? So that's also important to think about. And did both parties have capacity to make a contract? And we will get into what that means. So first, let's address that first question. Duress and undue influence. We'll start with duress. So duress is when someone is forced to do something against his will. This can be physical or it can be by a threat. So if conduct that appears to be a manifestation of assent by a party who does not intend to engage in that conduct is physically compelled by duress, the conduct is not effective as a manifestation of assent. This is the easiest one to consider, but the most rare that actually happens. So I don't know that you need me to really explain this. I'm not going to test you on it. There's no, look, if someone holds a gun to your head and says, agree to this offer and sign this contract, do you think there should be a contract? No, right? And that's basically all this is saying. If someone's forced to do something, that's not going to be a valid contract. Did you accept the terms? Yes. But not really, because of duress. And so that's the thing to point out about what we're talking about right now, is that without them, it looks totally like there's offer and acceptance. We're working toward a valid contract here. But any of these things, if they exist, there's no contract, because there's not actually an offer or not actually acceptance. What if it's more just a threat, okay, and it's maybe in the future? Not very far in the future. Think about it in terms of like assault. But first there needs to be a threat that's improper. That doesn't mean that you're going to kill them or you're going to sue them for something that doesn't exist. But one thing to note, that if there's something valid that you can sue about and you're threatening to sue about the valid thing, well, that might not be an improper threat. The other part is that there are no reasonable alternatives. So there can't be an easy option to get out of it. Otherwise, you're not really under duress. There needs to be inducement, and this is subjective. It's whether the threat induced the victim, right? So this is sort of the causation element. The threat needs to have caused the victim to agree. Undue influence. Now we're getting into things that are going to be a lot more likely than duress. So what is undue influence? We have a great case about it, but it's an unfair persuasion. When you're determining undue influence, the relationship between the parties is a huge deal. And so here's the typical fact pattern. The typical scenario is that the person doing the persuading has some relationship of power, perhaps a doctor or an attorney or someone very skilled or knowledgeable in a field. And the victim is usually going to be isolated or perhaps have some sort of infirmity, have some sort of unwellness. And then the deal made is going to be clearly unfair. This is undue influence. There is no requirement of misrepresentation. That means you don't need to prove that anyone lied about anything. All we need to see is that there was unfair persuasion. So I'm an attorney, and if I am working on someone's will, okay, for one, there's a rule that says I can't receive anything from a will that I work on. She doesn't have a lot of family that talks to her, and she kind of just lives by herself. All her friends have pretty much died off at this point, and she's lonely. And so she really enjoys coming to talk with me. One, I'm awesome to talk to. I'm a great guy, right? Okay. Not if I'm trying to use some undue influence here. And I say, you know what? I know you're considering moving into a nursing home. We get along. I love your house. How about you sell the house to me for $60,000? I know that she paid, $50,000 for the house a long time ago. And maybe I also know that the house is worth $100,000 now. So here we have the relationship of power is the attorney and the client, the victim who is isolated, a deal that's clearly unfair, right? Okay, yes, is she getting money for it? Has there been offer and acceptance and consideration? Yeah. Is she getting more than she paid for the house? Yeah. But we're looking at, she could have made easily $40,000 more. That's a pretty big deal. And sometimes the difference won't be that big. But as a general rule, certain people should not be making deals with certain other people. And we will get into that in class. Misrepresentation. There are two ways that this can exist. Fraud in the execution, which I'm not going to talk about much more than other than the fact that it means the document is fraudulent. So you make a deal with someone, and then in the document you change all sorts of terms, right? Well, then there's fraud in the execution. You got someone to sign something that isn't what they believed it to be. That's fraud in the execution. Don't worry about that. Again, it's just too obvious to test about. But fraud in the inducement. Fraud in the inducement means that someone's been tricked. And so we're gonna get into this a lot more. So the first type of fraud in the inducement is fraudulent misrepresentation. You see those three bullets? What are those? Elements. They're elements, which means you need to know them and understand them. The one thing to note about fraudulent misrepresentation is what this is typically going to be called is fraud. Okay, so this is just blatant fraud. It's intentional misstatement of fact that is justifiably relied upon. And we're going to go through each of these elements bit by bit. So what is the requirement of intent? Well, the intent needs to be to induce the assent, and the maker has knowledge or belief that the assertion is not in accord with the facts, meaning that you know or believe that what you're saying isn't true, or does not have the confidence that he states or implies in the truth of the assertion. So this is sort of the same thing as the first one. It's just making it more clear that if you say, oh yeah, I'm 100% certain of something that you're only 50% certain of, again, that's a lie. And you know that it's a lie. And then the maker of the assertion must know that he does not have the basis that he states or implies for the assertion. So this is, again, just knowing that what you're saying is not true. And it's broken up so that it's very easy to prove these different ways of lying, right? If we just had lying, well, all I did was say that I was more sure than I thought I was. And well, is that lying? Well, this breaks it up. We don't even have to ask that question. It is. It's easy to prove. Again, if someone gets screwed over this way, it needs to be easy for them to make things right. So let's talk about misstatement of fact. So the fact itself doesn't need to be material. What does that mean? Well, material is a very important term that we're going to get to. Something material is something that is extremely important in the transaction, that causes a party to want to be a part of it. For fraudulent misrepresentation, it doesn't have to be. It can be from concealment or from failure to disclose. So keep this in mind. If you hide something from someone, that's the same thing as lying. Okay, if your house has a bunch of water damage and you just paint over it, it might not be that easy to tell that it's there. Okay, you didn't say, no, there's no water damage, but by painting over it and hiding it, you've lied. Okay, it's the same thing. And that's the same with failure to disclose. In some circumstances, you have to tell people about certain problems. And the other side doesn't have a way to figure it out with just reasonable diligence by, how a normal person could go about solving these things, then you need to disclose it. And that's something that, again, we'll dig into more. Okay, so what else? Well, if someone offers their opinion, it's not a fact. And this is only going to be a problem if there's unequal bargaining power and experience. And the best case of the week is talking about this particular issue. So opinions are not facts, and so you can't rely upon them in general. If you are selling your car and you say, wow, this is the greatest car I've ever owned, that's your opinion. Okay, no one can rely on your opinion as a fact. It has to be a misstatement of a fact. So what if you're misstating the law? Well, listen, in general, you don't want to rely on the legal opinion of someone who isn't an attorney. That's not going to be, no one's going to feel sorry for you. It can actually be a statement of fact if you're talking about the subject in question. So if you're saying, yeah, I own this car and no one else has title to it. For example, if you have a loan, you can't sell the car without paying off the title first. It can't transfer to someone else. So if you say that it doesn't have a title, well, you are talking about the law, sure, but you're really misstating a fact about your car. In that case, it is a misstatement of fact. And assertions of intention. So what if you're a big commercial investor? There's some farmland outside of a city, and you want to buy that farmland to turn it into some suburbs. But that the farmer hates suburbs, and the farmer does not want his land to become suburbs. And so you go and tell him, I want this land because I want to raise cattle. The farmer says, okay, I can't really do it anymore. I really want this land to remain a farm. You have a deal. Then the contract is going to be voidable by the farmer if he finds out that you were lying once you start to do something that isn't farming on it. This only counts if the intention you assert is false, okay, and it's made with the intention to mislead. If you are saying what you think you might do, well, then you haven't really said anything explicit. But if you lie to someone about why you want to buy something, it might be because they wouldn't sell it to you otherwise, or it might be because they don't know how valuable it is. That is a misstatement of fact. This doesn't count where you change your mind, but in certain situations that's going to be up to a jury to determine whether you lied or changed your mind. A lot of how they decide it might depend on just how screwed that person got. Justifiable reliance. The plaintiff need only have considered the assertion an important factor and believed it to be true. So if you lie to someone and they know that you're lying, they cannot justifiably rely on what you said because they knew it was a lie. You don't rely on something you know to be a lie. But they need only to have considered it important. Again, this doesn't need to be the most important. It doesn't need to be material. It just needs to be something that they weighed when making the decision. This requirement changes a little bit when we're not talking about intentional fraud and the inducement. So let's get to negligent misrepresentation. So this is the same thing, except you don't mean to trick someone. You do it on accident. So you were negligent. And the standard here is generally that you were careless. If you were careless and made a mistake, well, it's going to end up being your bad. First, you need to be careless. Then it needs to be a misrepresentation. It's the same way we just talked about. And this time, it needs to be a material fact. It means it would be likely to induce the assent of a reasonable person or the recipient. Let's say someone is really interested in houses built by a certain architect, and you know that they really love this architect, and you tell them that your house was built by that architect, and you thought it was, but you never really figured it out. Like, you never bothered to look and check. Well, that would be kind of negligent. That would be a lie when it was untrue. It would need to be of a material fact, because even though most people don't care who the architect of a house is, most people don't know the answer to that question, this person did care. So it can be this person, the person in question, or just a reasonable person, either or. And again, they must justifiably rely. Just note that this time it has to be a material fact. What about mistake? Well, there are two ways that mistakes might be made. And again, we're talking about things that negate the offer or acceptance and void the contract. What about a unilateral mistake? Well, if you remember talking about a unilateral contract, that means it's one-sided. In general, the rule is too bad. You should have been more careful. You should have been more thorough. Too bad for you. The exception is if the other side knows you made a mistake, and we're like, ha, this sucker, we got him. Let's screw him good. Yeah, that's not okay. And I hope that you can sort of grasp that that's not okay. So the other side just can't know and take advantage of the mistake. But what if you both make mistakes? The mistake has to relate to a basic assumption on which the contract was made. Both parties need to be thinking of something that's important to the contract, and the mistake has to relate to it. And thinking that Bill Clinton only served one term as president. You're both wrong, but what does that have to do with the contract? Nothing. Okay, it needs to relate to a basic assumption on which the contract was made. It needs to have a material effect on the agreed exchange of performances. So what's going to end up happening here is that one party thinks they're in a very valuable transaction and the other party does not think so. So there's a lot of ways that can happen, but in general, the mistake needs to have a material effect on the agreed exchange of performance. It means these parties are going to be doing things very different than they thought they were going to be doing. And the party seeking relief does not bear the risk of the mistake. So if the risk is only one-sided, well, it's not, the mistake really isn't going to be so mutual. So we'll get into that in class as well. So we have one last way that we're going to toss a contract out. Capacity. So there are a couple ways that you don't have capacity to make a contract. And we mean mental capacity. We're saying you don't have the ability to make a contract. So the first way is if you're not old enough. So in the law, we talk about an adult as someone the age of majority, which is 18. You need to be 18. And this can vary from place to place, but we're just going to, pretty much everywhere it's 18, and we're just going to roll with that. A minor can void their contracts up to and within a reasonable time after reaching majority. And there are some exceptions, but what this means is that if you're 16 and someone sells you a car, you can get out of that contract and give them the car back and get your money back until a reasonable time after you turn 18. When you're 18, you can affirm the contract and say, yeah, I definitely do want to be a part of this. And then after that point, it's done and you can't go back. Or you can say, wow, this should not be happening. Now, why do we do this? Well, a 16-year-old is not going to just sort of by default, probably not going to have the sort of knowledge of just sort of human interactions in the adult world that can avoid their contracts up to and within a reasonable time. So we're just saying we don't want someone who's some swindly car dealer screwing over a kid because they're a kid, right? That's kind of the idea. So we give them a way to get out of it. The other way is people who are mentally ill. So contracts by mentally ill people are generally voidable by that person, either by their guardian or when they regain their sanity. And yeah, people regain their sanity all the time, especially if you're in the hospital setting. Someone will often not be acting like themselves in some way, and sometimes will be very far from themselves. Until that person is lucid again, their contracts are going to be voidable. And again, if they're not, which that happens all the time also, then a guardian can void that contract. So what if you're drunk? Well, if you're drunk, well, too bad, okay? Because the way the law treats it in general is that you chose to get drunk. You know if you get drunk, you might make some bad decisions. That might be why you're getting drunk, right? Is to make some bad decisions. I don't think if you're thinking about that, you're probably not thinking about entering into a horrible contract. That's not the typical connotation of a bad drunken decision. But, that's what we say. When you begin drinking, well, the results are kind of going to fall on you after that. But if the other party knows that you're wasted, then that seems a little bit dishonest on their part, and then a contract can be voidable. So if someone takes advantage of you because you're drunk, that's not going to be okay, and then you would be able to void the contract. For both of these contracts, for minors or mentally ill or intoxicated, the contract exists. It is not void, but it is voidable. So it can remain a valid contract. Everything can be just fine, but these parties will have the option causing the contract to no longer exist. There are some exceptions. With necessities, if you're getting a place to live or things that you have to have in American society, and I do not believe that's going to count a data plan on a smartphone. Although you can't even do that underage anyway. You want to know why? Well, no one wants to deal with this argument being made in the contract. That's not a necessity, and the contract would be voidable, right? So we don't want to do that. So that's why you can't do something like that when you're a minor. But necessities, a place to live, and that counts, and that one's big on mentally ill also. If you furnish someone a place to live and give them food, these things they need, well, you're not really going to be able to renege on that. If something you need isn't really an option, and so it's hard to go too terribly wrong as far as it being voidable because of this reason. Then there are some contracts that simply are not voidable. That can be education, that can be your medical care, okay, or insurance. These sort of things are not voidable because the law says so. Why? Because all of those places have money to lobby and make sure their contracts are going to hold up. Misrepresentation of age. If you go to buy a car from that person and you say, yeah, I'm 18 or I'm 19, but you're actually 16, well, that's not really fair to that person because they didn't believe they were getting into a contract and it could be voidable. Right? So that wouldn't be fair to them to allow it to be voided. But this is really interesting because if we're entering a contract, and perhaps it's for a large amount of money, it can be pretty serious. If you lie about your age, the other person isn't on the hook for it. We're talking about potentially large exchanges of money. The misrepresentation is then on the fault of the younger person. Ratification. So I told you when you turn 18, you can say, oh yeah, I definitely want to be a part of this contract. Well, you can no longer void it. It's just like you were an adult when you made it at that point. And then there is a duty to return consideration received. So the point of contract law in general is to put parties either back to where they were if there hadn't been a contract, or to where they were if the contract had been performed properly. That's usually what we're going for. It's not so much about large money damages and all that stuff. It's about enforcing promises. And that is it for the week. We will hit this stuff hard in class, and we have an exam, so have a good one.